in the agreement that would help that I think should be included in the agreement. So first of all, a single market is hailed as a potential growth accelerator for micro, small, and medium enterprises. According to the World Economic Forum, MSMEs are responsible for more than 80% of Africa's employment and contribute up to 50% to its gross domestic product. In the case of Nigeria, that percentage is even higher. I think it's about 90% of employment in Nigeria that MSMEs contribute to. And therefore, IP protocol is expected to facilitate the growth of MSMEs in many ways. And the ways they can help is first is through the IP protocol should focus on eliminating the differential treatment of the AFTA countries. This difference emanates from the participation of different countries in different multilateral and bilateral IP rights treaties. For instance, some countries are not members of the World Trade Organizations, so they cannot benefit from its provisions and principles. Also, the IP protocol should leverage on already existing regional IP provisions, such as African Regional Intellectual Property Organization, that's ARIPO, and Organization African de la Propriété Intellectuelle, OAPI. Through though countries like Nigeria, South Africa, and Egypt do not belong to any of these systems. These two systems they provide for a very cheap, easy, and effective way of extending IP protection to participating countries. These institutions should be accorded support for effective implementation of the policies, as well as extending their membership to include all African countries. Also, the protocol should also focus on opening the continent's markets. This may be attained by reviewing member states' laws and policies regarding exhaustion of rights. This exhaustion of rights is also known as the first sale doctrine, and it provides that where the IP right owner places a protected goods or work in the market, they cannot subsequently prevent its commercialization. The market in this instance is usually limited geographically. Currently, most African countries operate either national or international it, international exhaustion. So the laws and policies ought to be streamlined to provide for a regional exhaustion, making the entire African region to be regarded as one market in line with the objective of the AFTA agreement. There should also be a comprehensive review to investigate new developments such as trademark registration for services, new types of IP rules gaining prominence as a result of technological developments, relevant rulings, and further development in relation to the existing international agreements. This could lead to the adoption of new undertakings. There should also be a unified approach with regard to IP rules matters in Africa. The present state of affairs is characterized by some degree of fragmentation. This undermines the use of scarce resources and of legal certainty. There's, there should also be cooperation and technical assistance on compliance with the major global intellectual property agreements. There should also be consideration of the appropriate role of international registration systems, such as the Patent Cooperation Treaty, the Hague system regarding registration of designs, and the Madrid Protocol regarding the international registration of trademarks, agreement on consistent approach in using these systems could benefit the use and protection of IP rules in Africa. There should also be cooperation in the fight against the production of and the trade in counterfeited and pirated goods in Africa. We know that most of developed world like China's, they bring goods, even those goods that are not that substandard, they bring them to Nigeria here for us to consume. So things like this should be regulated as well. Then the IP rule should also focus on in on intellectual property regimes that are not sufficiently exploited in Africa. For example, geographical indications, plants, variety protection, and the protection of genetic resources, traditional knowledge, and cultural expressions. Under the geographical indication, this is a sign that is used on goods that have a specific geographical origin and possess qualities or a reputation due to that place of origin. In Africa, this type of protection is very important since Africans' geographical products typically have qualities that derive from their place of production and are influenced by specific local geographical factors. For instance, in Nigeria, when you talk of Irish potato, your mind goes straight to Jos. When you talk of cocoa, your mind goes straight to Ondo State, and some other products too like that. Article 22, sub 2 of the World Trade Organization agreements on trade-related aspects of intellectual property, it allows countries to determine which form of protection would be appropriate for geographical indications. In 2017, the African Union adopted the Continental Strategy. The strategy recognizes the importance of geographical indications as a tool for use in sustainable rural development and food security. Subsequently, communities will be able to economically leverage the unique qualities of geographical products based on their geographic areas of production. The exploitation of benefit associated with geographical indications by local communities is expected to result in economic development, especially for women and the youth. The protection provided must be defensive. This will empower communities to promote their traditional knowledge, control its uses, and benefit from its commercial exploitation. In conclusion, the AFTA's agreement's objectives are very achievable should the IP protocol focus on the harmonization of policy and laws by setting minimum standards and effectively tackling the aspects of intellectual property that are under commercialized in Africa and whose protection can open up revenue generating avenues for the African countries. Thank you.
Thank you very much, Christina. That was a very robust and in-depth research and presentation. Thank you. So I'll just call on Mr. Marx to open the floor and to comment on your presentation. You're welcome, Mr. Marx.
Yeah, thank you, Juliana, as always. And it's a pleasure to be on the session this afternoon. Apologies, at some point I may be a little in and out of the session. And I also apologize, I didn't get to hear much of Christina's presentation, but I heard a few parts, and I think that's what my comment would be on, which is Africa focusing on some of the emerging areas of IP. And I always say that because I think some of the more traditional areas, we already have lost a lot of ground. And one of the areas I think Africa should really be looking at a lot. I believe Africa still has a lot of benefits would be in the areas of traditional knowledge, of course, folklore and cultural expressions. Africa still has a lot of that area of its life very intact. And it's an area that the world is increasingly finding interesting. So using African stories, African folk expressions, and then of course even genetic resources, including herbal drugs and all that, which we have a lot of in Africa. So it's an area that we should look at. One successful example is the case of, I always keep forgetting the name, the anti-sickle cell drug that was produced in Nigeria at the time, even though we ran into a lot of trouble. And I think at the end of the day, the patent expired without it really making a lot of traction in the market. But in the course of developing that drug, there was what they call a benefit sharing agreement entered between the Nigerian Institute for Pharmaceutical Research and Development that developed the drug with some of the local traditionals who gave the idea on how they, gave the traditional knowledge on the use of those particular genetic resources, some traditional plants that were used to make the drug. So Africa should be looking certainly at increasing the international reach of IP within the areas of traditional knowledge, genetic resources, and and those areas. So that's one area she presented that I think I agree with, that Africa should look at and also put in the front burner, for instance, when negotiating in the World Trade Organization, for instance. Those are some of the areas that Africa should be happy on. Just the way, for instance, I always say France, I ensure that they have written what they call it, geographic indications for their wine and spirit products into the TRIPS agreement. That's the trade-related aspects of intellectual property, one of the agreements managed by the World Trade Organization. So what has happened with that is that France has enhanced protection for wines, for instance, champagne that comes from France, in the international arena, because they played their international politics well and ensured that they got themselves ingrained into that agreement. So Africa should also be thinking about doing something like that. So that would be all my presentation, my comments for now. Thank you.
Thank you very much, Mr. Marx. Mr. Folarin, thank you for joining us. Over to you, sir.
Good afternoon, Juliana. Thank you very much for inviting me on this platform. And good to see you, Bernice, again, second time today. Good to see you too. Thank you very much for that interesting presentation. I think I must say that I agree with everything that Marx said, and I disagree with everything that Marx disagrees with. But on a more serious note, can you hear me?
Yes, sir.
Okay. On a more serious note, there's a huge conversation to be had on the AFCFTA and the IP considerations. I do agree that there's a need to look inward as opposed to outward. I am a little cautious about joining associations. I'm a little cautious, and the reason is that oftentimes, one of the rules of scientific principle of diffusion tells us that particles in the air move from areas of high concentration to areas of low concentration, and it tends to happen like that to trade-related issues. People would naturally gravitate towards climates that are more conducive. There was a time in Nigeria when we had so many print publishers, and it wasn't so long ago, maybe about 20 years ago. But all of a sudden, almost overnight, everybody started packing up and moving to Ghana because the cost of operation in Ghana was not as high as it was in Nigeria. There was constant power in Ghana, and there was a political stability to some degree in Ghana, and so you'd find that businesses will ordinarily move to places where they feel they have a convenient, working environment. That's one of the reasons why I think it was after the NAFTA, the North American Free Trade Alliance treaty was signed by Bill Clinton in, I think, 1994. We found that about 1 million+ jobs were in manufacturing were lost in the US. And how did that happen? Companies found that it was cheaper to manufacture outside the US than within the US. So a lot of car manufacturing companies shipped off to Mexico, and a few years down the line, the US joined an accord. I mean, whether I like it or not, it's called the Paris Climate Accord. And under the Paris Climate Accord, there were environmental requirements, compliance requirements and taxes. And because of those requirements also, by complying with those requirements, the US forced companies, it became more expensive for certain companies to operate. And so those companies naturally looked for climates that were more conducive. So they went to China, they went to parts of Asia, and so on and so forth. So you find that I'm not always in a hurry when it comes to joining treaties to encourage. It's not always a thing of, oh, others are joining, so we should join. It's not a bandwagon thing. It's important that one should consider, in the abstraction, especially the long-term effects of joining or not joining. So I would say, with regards, IP is not a silver bullet that will fix or kill all the werewolves, or cure all the problems of SMEs. But I do agree to a large extent with Marx that with regards to TK, traditional knowledge, and areas of areas of expertise that we have already developed. For example, places like Nollywood, entertainment, and so on and so forth. I think there's a lot to be said about how we can capitalize on these areas. But all in all, I think your presentation highlighted. Hello, can you hear me? Okay, your presentation really highlighted some of the important conversations that we need to have. I think you also highlighted, though maybe inadvertently, the dichotomy in Africa between French-speaking and English-speaking Africa. OAPI, I was talking about, I think Daniel's mic is on. Sorry. Okay, I'm talking about OAPI and ARIPO and the rest of Africa. I don't necessarily think that Nigeria, in my opinion, should sign up because others are, but there are implications. And the truth is, our closest neighbors, we don't speak the same language, the same lingua with our closest neighbors. So that there's a disconnect there. But then there are services that we can sell to them, on a large scale. So the question I think there should be some selfishness. We need to think of Nigeria first, because you can't think of Africa when Nigerians are hungry. And now, just an announcement this morning, in Abuja, all the 12 stations became filled up again. There's clearly a need to create a market that we can consume, or at least to create policies that will favor Nigerians or create wealth in Nigeria before we start, thinking about how to export that wealth to other places. But yeah, I think I agree with a lot of the sentiments. So once again, a lot of the sentiments you expressed in your presentation. So once again, I would say well done. I think with regards to the AFCFTA, most free trade agreements, or most trade agreements, at least almost all the trade agreements in the past, maybe 30, 40 years, have had more of a disastrous effect on the economies of the larger countries. So it's a good thing that we're still negotiating the second phase of the AFCFTA. So there's still the opportunity of, coming to some kind of arrangement that will favor us and then favor the rest of Africa as well. So it's good that you're shining a light on this. Thank you very much.
Okay, thank you very much, sir. Okay, so I think that what I'll just add to what you have said, sir, and what Mr. Marx has also said is that I think that the aim of this agreement is to, yes, foster trade, that's ease of trade, etc. But I was part of a meeting where someone was talking about the underlying factor of why most people might know that things are infringing materials, yet they'll still go ahead to purchase those things, and that's poverty. So in Africa, there is like a high level of poverty. So even if people know that this is a fake CD or this is an original CD, they might still go for the one that is fake. And even if they know that this is an original shirt and this is a fake shirt, they might just go for the one that is fake. And so if there's the free movement and all that, and people are coming up with counterfeit goods, etc., people might still go ahead to get those things. So it would be good for, I think, beyond signing this agreement, African governments should generally look at how to improve the status of their citizens. Then I'll also talk about the awareness. So it will be good for the awareness to be heightened so that people can know that, okay, this is what the government is doing and these are the advantages, etc. Then for the geographical indication that you also spoke about, I'm not sure if Nigeria is a signatory to the Lisbon Agreement. I think that's the agreement that is in charge of geographical indication. And even for the ones that were signatories to, some have not been domesticated yet. There was a meeting I was part of, and somebody was arguing that even if we're not domesticating these agreements, that they can still be persuasive and they can still be used and all that. But I think we should learn how to go all the way if we're actually doing something. So we should do our research first. And then if we decide to go into something, we should actually go all the way. So I'll just stop there because of time, and I will be calling on our second speaker. So let's hear from, let's hear from Tony. Hi, Tony, can you hear me? Okay, so if Tony is not here, then let's hear from Bernice. Hi, Bernice, can you hear me?
Yes, I can hear.
Okay, Tony, are you ready? Okay, so Tony or Bernice, either of you can have the next presentation. Okay.
Hello.
Hello, Bernice.
Okay, I'll just go first. Why I can't share my screen.
Okay.
Yeah. So I wrote on IP audits and valuation because I noticed that a lot of people make, comments about it. As an IP lawyer, you're supposed to do IP audits as part of the roles you're supposed to do. So I just made like a small research on like their definition and their importance. So intellectual property is an important part of a company's assets. It's part of the non-physical property of a business. They are legally protected and the protection can be enforced in a court of law. IP audit is basically a systematic review of the company's IP assets, related risks and opportunities. It involves a thorough review of the company's IP assets, IP-related agreements, policies and procedures with the competitor's IP also. So in order to properly do an IP audit, you're supposed to look at all the documents, maybe an independent contractor agreement, employees agreement. What is it in the agreement that may take away from the rights of the IP that is already owned by the company and all of that. So the importance of doing an IP audit is basically to identify if the IP is owned by the company, because there are a lot of businesses that, do not know whether or not their IP rights belongs to them. They just know that they are carrying on. They don't even know that it's an IP right, or they don't know that they have intellectual property in this. So maybe they've secured a domain name and social media names, like I said last week, but they've not trademarked it. So they think that by having domain names and social media handles, they are already protected, but only to find out that they are not actually protected. Also, the importance of IP audit is to preserve and enhance the value of existing IP. When you do an IP audit, you probably know the value or the yes, the value of your IP. So when you're negotiating, you're able to, say this is what it is. This is what you would price for your IP in case you're licensing it out and all of that. IP also identifies new opportunities for profits. So when you probably wrote a book and you want to turn it into a movie, when you carry out frequent IP audits on your IP rights, you discover that, oh, this is an avenue where you can make money. This is a place where people want to see. So if people are not readers, at least they can watch movies and see that is it. So when you are doing that, you can come to this decision by carrying out IP audit frequently. It also identifies roadblocks and prevent costly disputes. It also facilitates and optimizes business transactions. What is IP valuation? IP valuation is the process of determining the monetary value of an IP asset. It essentially, IP valuation comes from the fact that you are able to exclude competitors from, using your IP. The importance of having an IP valuation: if you carry out frequent IP valuation, you'll be able to secure financing. For instance, there are brands like Google, Samsung, Microsoft. They have high valued IP. So if they want to take loans, or they want to go into a particular business, a lot of banks will be willing to give them, because they know that their IP value is one of the highest in the world and all of that. So it also attracts investors and partners. So nobody will want to invest in a business where the business owners do not know the value of their IP. Maybe like they've not even protected it in the first place. So you're telling people to come and invest in your business, but you've not protected it. So why would they want to invest? Because they do not have the rights. You don't have the rights to enforce. So if it is exclusive, people would want to invest in that kind of business. Also, when you're going into licensing and franchising agreements. Hello, can you hear me?
Yes.
So when you're going into licensing and franchising agreement, when you know the value of your value of your IP, you probably know what royalty you expect back, because you are able to value how much customers will be able to go patronize the franchise company or something. You will know that, okay, this is the value at which my business is worth. So I know that a lot of people will be patronizing you. So you know how much to ask for royalties and all of that, all of those. Then dispute resolution. When you know the value of your IP or carry out frequent IP valuation, you'll be able to know whether your IP right is infringed. Maybe you used to check the trademark registry and their books, and when to conduct IP opposition and all of that. So that's like the end of my presentation.
Thank you very much, Bernice, for this presentation. I think this topic on valuation and auditing, it's something that not everybody jumps on, because it's not so easy to do, especially the valuation part. So kudos for actually going ahead to research it. So I'll just call on Mr. Marx to drop his comments on it.
Yeah, thank you, Juliana, and thank you, Bernice, for that presentation. Yeah, I think you've touched on a very important topic: IP audit, and of course IP valuation. I think that's one area that lately businesses have become alive to. I mean, it was the days gone by. Yeah, people spend a lot of money doing the inventory management, auditing their stocks and all of that, their physical assets, but paying no attention to their IP assets. But of course, events of recent years, I think one of the very popular issues was one of these, I think IBM. IBM was almost going bankrupt as a company until, they engaged a new, I think it was a finance manager also, who decided to look into their IP portfolio, and then saw a lot of opportunities for licensing and cross-licensing and making new streams of revenue out of the IP they already had, and that alone changed the fortunes of that that company at the time. But another important thing was that another place people fail to realize what an IP audit also does for you. Because if you have heard the popular saying in recent times that cost is the new profit. So what simply means is that for a business, when it comes to paying tax, of course, you are allowed to deduct all your costs before taxes apply to your profit. So for a lot of companies, what has become more important to them when it comes to accounting now is no longer the profit they actually make. It's how much they can enlarge their costs to ensure that the amount of tax they pay is reduced to the barest minimum. So doing an IP audit, for instance, will reveal to you certain costs that are attached to your IP that you have taken for granted for a while, and bringing those costs into your balance sheet, into your profit and loss account, and into your accounting books would ensure that you are able to carry or justify more cost that your business spends promoting its IP and all of that, and then in return you are able to reduce your tax burden overall. So that becomes another advantage that an IP audit brings. Then of course an IP valuation is always important, because IP is valuable property, and anything that is valuable needs to be quantified, because value is is in reference to quantification. Because if something is valuable and you can't place a quantity on it, at least in the business world, then it means you are not really going to be able to get benefit out of it. So Benny's mentioned, one of the hot topics at the moment now is IP collateralization, using IP as a collateral for seeking alternative sources of financing or funding. Sorry, so IP becomes important in that role, and for anyone to take you serious enough to advance you money against your IP, then you need to know that there's a valuation for that IP. So, and typically when it comes to IP valuation, because it's subjective, it's not exactly objective. You can value that thing objectively because somehow there's similar transactions you can easily benchmark against. But when it comes to IP, sometimes what you need is just the professional opinion of a person who looks at that and says, considering everything, considering your sales, your turnover, and all many other metrics, this is what the value of your IP, say your trademark, is. So because of that, when it comes to IP valuation, it's important. I just want to make that point that the owners of the IP themselves should have some internal IP valuation done, so that whenever you are going for an external IP valuation, you have something to benchmark against. So it's an important topic, particularly for SMEs, and the IP valuation techniques are quite easy to apply even at the lower levels for SMEs and for smaller businesses. So it's something that businesses should pay more attention to. So overall, thank you, Benny. That was a good presentation. And back to you, Juliana.
Thank you very much. Mr. Folarin.
Hello, Juliana.
Yes, sir.
Okay. Yeah.
Pay your contribution.
Yes. Thank you, Bernice. That was a very interesting work or talk on IP value. I agree with all the reasons that have been canvassed. Valuation is important. I think also for the hello.
Yes, sir.
Okay. Also for the reason that you don't know the value of what you have, and I think we should have more conversations about valuation, especially in the context of, in anticipation for litigation, because as Marx said, valuation can be and often is very subjective, but to a large extent, you find situations where the rightful owners themselves have, but there is some objective standard, and you find that to a large extent, rights owners have a very high and overly high estimation of the value of their work,
Okay.
Yeah, but so it's a good conversation to have. I think as part of the process of pushing IP awareness, there also should be more awareness about the true value of IP, or at least about emphasizing the true value. So I find, for example, somebody who an artist, for example, who may not have sold up to 1,000 CDs in the days of CDs, for example, wanting to sue somebody for millions and millions of naira because somebody copied the song of the other. So there's also that component to ensure that at least there's a realistic feedback loop. If you look at the fintech industry, valuation in the fintech industry is, everybody knows that it's over the top. Most fintech companies are valued way higher than their actual value is. And so a lot of people are predicting, well, not a lot, there are predictions that there will be a fintech bubble, there will be a bust, a few years down the line. So whether that happens or not remains to be seen. But I think I should say kudos to Bernice for highlighting an area that not many people venture to talk about. Thank you.
Okay, thank you. So I'll just add that when you talk about IP audits, that's coming from a legal perspective, or as a lawyer, if someone calls you that, okay, I want you to audit my firm or whatever, to just check to see like the IP I have and how I can maximize it, etc. So what you're doing, first of all, is to even identify what is IP. So if you look at it, you see that, oh, they have a trademark that is not registered or is registered. They have things that they can go ahead to copyright. Maybe they've already done that or not. Probably they have licenses or agreements that they've to license, maybe patent, trademark, etc. So you have to look at like that chain and see everything that they have. Then you can then advise them to go ahead and register it. Then you can also check if maybe what they registered is actually dormant or if it has been renewed. Because like for trademark, there's a renewal period. So you as a lawyer, you're also supposed to advise them to go ahead and renew if it's time for them to renew that. Then also, Flutterwave, there was a news on Twitter, I think it was 2 or 3 days ago, about Flutterwave, that they valued the company, and it's a Nigerian company, and it was $1 billion. So I don't know if they also valued the IP, but that's what valuation is about. And now that Flutterwave has been valued, more people know about it and more people are interested in it. And now they know the status of their company and how to go about like a lot of things. So it's the same thing with musicians, etc. For an upcoming artist that doesn't have anything, the value of his IP might not be so high. But if you see another person like who is popular now, let's say Burna Boy, Davido, etc., their own valuation for their work will be higher than someone that's just starting. So but I don't think it's like the responsibility of just lawyers to like take that valuation part, because it's a bit mathematical. So I don't know if a lawyer is good at that, fine, but you can also invite people that are more skilled in that to actually handle that part of it. But if it's for the auditing and for knowing what IP they have, what have been registered, and probably they registered something that is making them to lose money, you can advise them that, okay, you don't really need to keep maintaining this particular IP since you're not using it. So I'll just stop there, and then I'll call on Clarice to give her own presentation.
Hello?
Hi, Clarice.
I hope you can hear me.
Yes.
Let me just try and share my screen. Okay. So my presentation is on the impact of e-commerce on IP, and this was inspired by a Zoom meeting that Mrs. Juliana did with Uche on IP law and e-commerce and the challenges. So we are currently in an era where everything is driven by technology, and this is more apparent, especially right now when we are in a pandemic. We can attend our classes online like what we are doing right now. We can attend our meetings, we can attend court online, and we can also purchase goods and services online. Like right now we have Facebook Market that was just introduced the other day. We have Instagram Shop. We also have these applications such as Jumia, Amazon, eBay that allow people to trade online. And this has forced a lot of businesses to change their business models. Most of them are moving from physical stores to now online stores. So we have a lot of Instagram stores, we have a lot of Facebook stores. But as this technology makes things easier for both the consumers and businesses, we need to ask ourselves what implications it will have on IP. So what is e-commerce? E-commerce, basically, just from its name, it's the buying and selling of products and services via electronic systems such as the internet and computer networks. And the well-known e-commerce websites, Jumia, Alibaba, I was told OLX changed their name to Gigi, AliExpress, Amazon, etc. It's said to be a global economic giant, and WIPO actually conducted a survey in 2009 during the December holidays and reported that consumers in the US spent approximately 27 billion US on online shopping. And it did another survey in 2015 and reported that e-commerce sales worldwide amounted to 1.55 trillion. So you can really see that e-commerce is a global economic giant. So what are the implications of this e-commerce on IP? So e-commerce, it affects IP both positively and negatively. So we look at the positive and then we look at the negative impact. So for the positive, the first one is that brands are now able to trade online. Hence, they increase their online presence, they increase their worth, and they're also able to gain profits. The second one is that it has increased businesses and society's awareness of the growing importance on IP. Right now, we can see when people are posting, let's say someone has a business and is posting its pictures online, you can see they are putting those watermarks, they're putting the copyright symbols and whatnot. So it's increasing the awareness on the importance of IP. Another thing is that there is the increase in new technologies. So, for example, Jumia, these are new technologies that are coming up, and hence it's fostering innovation. So we can say that e-commerce fosters innovation. And the negative impact, the first one is domain name issues. And I put this case here to just illustrate the kind of issues that we are talking about. So this is a case of Nike or Nike, the way you pronounce it, versus Circle Group. We know Nike uses "just do it" as their slogan. So Circle Group registered a domain name, justdoit.net. and Nike sued them. No, they were using the justdoit.net to actually point traffic to their own website. So Nike sued them for domain name infringement. So we can see we'll have a lot of domain name issues when it comes to e-commerce. And then the second one is illegal downloads. This is a very famous case, state versus scheme.com. There's this website that was called Mega Upload. I think I once used it when I didn't know much about IP, but now I know better. Mega Upload was owned by this guy called Kim.com, where you could go there and you download any music, any movie, any video that you want, whichever country you want to view from. Everything was there. And this guy, he made millions out of it. He had almost over 60 million registered users. He was a big man. He owned mansions all over US, and he was arrested for copyright infringement. The case is actually still ongoing because they're trying to extradite him so that he could be able to answer for his crime. Another one is counterfeiting. Amazon, and this is actually a recent one just the other day. Amazon, we know Ferragamo, the famous Italian luxurious brand, and Amazon, they have sued sellers on Amazon, the sellers that are on Amazon selling knockoff belts and bags from Ferragamo. So this is also still ongoing. Another negative impact is jurisdiction. So with jurisdiction, it's unclear which courts will have jurisdiction over issues that are relating to e-commerce. This is because, let's say I'm in Kenya and I'm selling counterfeit things on Amazon to someone who is in Nigeria. So it's very unclear the jurisdiction, which courts will have jurisdiction over such disputes. And then the enforcement bit is also an issue because it's difficult to enforce intellectual property on the internet. One, you may not even find that infringer in the first place. That one could be using a pseudonym or something. It's very hard to track the infringer. And two, even if you do and your lawsuit succeeds, it will be difficult to enforce the judgment in another country. So that was my presentation. Thank you.
Thank you very much, Clarice. I think it's a very intelligent presentation, and I've actually also learned from your presentation. So I'll just call on Mr. Marx to give his contribution.
Okay, yeah, thank you again, Juliana. Well, apologies. It was just after my last contribution I noticed that Mr. Folarin Aluko was on the call this afternoon. Apologies, because I've been kind of on and off, so I wasn't listening after my presentation earlier. So yeah, it's good to, of course, hear the voice again of my boss, Mr. Aluko. So, Mr. Aluko, my hand on ground. Apologies, I didn't acknowledge you initially. I didn't realize you were on the call. So yeah, so on Clarice's presentation, yeah, Clarice, thanks. You touched some really important points when it comes to the intersection between IP and the intersection between IP and e-commerce. IP actually, e-commerce has been one of the has been a development that has thrown up a lot of issues about IP and given IP a lot of prominence. Of course, underlying it all is when you look at traditional commerce, of course, was physical location based. So if I want to buy particular product, maybe Ferragamo product, I go to a Ferragamo shop in a mall. But with e-commerce, it suddenly made it possible for trading, for the vendor and the vendee to be at different locations entirely from each other. So what that does is that for the for unscrupulous vendor, it has made it a lot easier for them to carry out their trade, because when it's physical location based, it's a lot easier to control, say for instance, issues of counterfeiting. It's a lot easier to also control issues of people selling licensed products without appropriate licenses. But once you go on you go online, the fact that things are almost to an extent anonymous online means people can more easily infringe on IP online without getting caught or without being detected. So that opened the vista where suddenly IP realized that IP has to up its game to be able to regulate this new uncharted terrain of electronic commerce. And I think that we have seen a lot of traction, in that direction, and that has also beyond just e-commerce. That has also changed to a large extent the whole IP landscape to a large extent. So I think that would be the extent of my contribution. Clarissa had done a good job pointing out. Okay, the only other thing I wanted to add is Clarissa would help you also to look at you talked about jurisdiction, to look at there's a model law, I think, on e-commerce, electronic commerce, done by the UNCITRAL, that's the United Nations International Commission on Trade Law. If you can look up something they did on that, it will benefit you as well on the issue of jurisdiction, on how they have tried to apportion jurisdiction when it comes to e-commerce claims. Of course, noting the fact that you have said that territory, getting issue of territoriality in those claims can be a little bit difficult. So that, I believe, would help to throw more light on that aspect as well. So thank you, and back to you, Juliana.
Thank you very much, Mr. Marx. Over to you, Mr. Folarin.
Thank you, Juliana. I want to also hail the secretary, the powerful secretary of the MBA Anti-Corruption Committee. He's a very powerful man. That's no other person than Mr. Marx Ikongbeh. I salute you, sir. I heard all the things you're saying. Anyway, God will judge you. But also, on a more serious note again, I don't know, the topics you guys are picking are just, they are topics that I have a lot of interest in. I'm sorry, I was a little distracted earlier. This is my third event for today. But
sorry
quite. No. I'm enjoying it. I'm enjoying it. I love the conversation around valuation. I'm just sorry to take us back. I talked about fintechs and the valuation bubble, and Juliana mentioned Flutterwave, and the valuation. Especially when it comes to fintechs, there's a special, they use some voodoo valuations, but that it's part of the conversation. And I think a lot of them factor IP in, and they factor a bunch of things that ordinarily one may not necessarily factor in. But anyway, that's for Flutterwave. Great. E-commerce is also an area that I am very much interested in for many reasons that I won't bother to go into here. In fact, I'm part of a group that actually we've been conducting some research now for the past, I think Juliana knows something about this, for the past maybe 10 weeks or so. We've been trying to measure some metrics on e-commerce metrics in Nigeria, and the numbers you raised or you made reference to are nothing compared to current numbers, especially in 2020 in terms of sales. Globally, I think Nigeria currently ranks in the top 10 in terms of the volume of e-commerce transactions from 2019 to 2020. But the market is still untapped, and that shows what the potential is. And if you just open up Instagram, you will see like 1,000,001 people offering this course on Amazon FBA, this and that, drop shipping, up shipping, down shipping. So it has given rise to several business models, that range from the downward, from those that are downright, illegal, to the legal. And I think you captured, to a large extent, some of the shady bits or the shady parts, especially with drop shipping. It has become easy for people to just pick up well-known brands, and now that you can go on sites like 1688 to order, low quality or substandard or goods, and then customize them. Goods made in China, customize them, rebrand them, and sell. Hello?
Yes,
Hello?
we can hear you now.
Oh, you couldn't hear me before?
For like a split second or two.
Okay. So I was saying that, e-commerce as a business model has given rise to several other, opportunistic exploitations or avenues for exploitation that touch on IP. So I was talking about, drop shipping and how it has become easy to just order something from a store in China or in Shanghai, and then customize it. So there's trademark infringement. You mentioned Kim.com. I followed Kim.com for several years. I followed Mega Upload, and I've also tracked the case too. I don't think he's going to be extradited, but from whether it was from Napster to Mega Upload, and then these days now to the direct download guys, there's with new technology comes new ways of infringing or new ways of accessing content. But if you look at the Mega Upload, since you mentioned Kim.com, if you look at the Mega Upload case, it shows that there's clearly a disconnect between supply and demand in the world in terms of access to information and access to protected content. And I'll just maybe in rounding up, I'll say this, there are many websites from the West that are geo-protected. So what that means is you want to go to Hulu, for example, you can't visit a Hulu site from some parts of Africa because the sites are geo-locked. There are some apps you cannot use because they are geo-locked, and so you find people having to use what do you call them, VPNs, to avoid some of these restrictions. The reality is that there's a huge market out there for content, and the potentials. I don't think we've ever seen the kind of volume that we're seeing now in the world. But clearly, there's a supply problem, and it does make a strong case for the potentials that we have in Africa to first and foremost satisfy our own supply. So supply the needs to satisfy our demand. Before we start talking about going outside, I think that's one area where India and China, even though I'm just comparing the markets, not the governments now, seem to have gotten it right. These two markets can supply their very teeming populations and then also export outside. So again, I think you highlighted most of the major issues that have come that we see today as a function of the boom in e-commerce activities. Well done, good stuff. But again, if you look at the numbers, I think Statista.com also has current numbers on e-commerce data from 2020, and you'll find the numbers are staggering. They're very huge. So the question I'll ask is, why are we not? What are we doing to encourage that people in that space? Thank you.
Okay, thank you very much, Mr. Folarin, and thank you, Mr. Marx. So I think I'll just add that when it comes to like infringement for e-commerce, personally, okay, I've seen that it can be from different sides. So we can have where probably like there's an issue between that's e-commerce company and the suppliers. So there was someone that reached out to me. What they do is that they supply news to like people to read and all that. And the person that he was supplying this news to, a very popular news company, they actually stopped paying him, and they were like, no, they're not paying him again. They're not interested, or wasn't him that said he was not interested. But they now started going to his site to pick his own news and then to put on their own site. So those are like things between, that's like disputes between, I think he was an independent contractor actually, and they were then doing this. So they were infringing on his right to satisfy their readers online. Then there are also those into the goods and services, and someone else reached out to me and he saw a particular site that promised that they were going to give him, I think, slots to sing and to perform and all that. And they asked him to pay a certain amount and he made the payment. And after making the payment, they stopped replying his email. Now, he did not go through the terms and conditions on the site. And so by the time he came to me, I was like, did you actually go through the terms and conditions and the privacy policy, etc.? And he was like, no. I was like, okay, let me go and read it. And by the time I read it, I discovered that part of the things that they wrote in the terms and conditions was that they would not refund, that it's non-refundable, and some other things that was just totally out of it. But you know that as consumers of these goods and services online, most of us do not read the terms and conditions. And even with Facebook, WhatsApp, etc., like a lot of people don't even go to read it, or even Gmail, Yahoo. What are the things that will be done by the time you are dead? Do you want them to hand over your Gmail to someone? Do you want them to close it down? Those are discussions that people don't look at, or things that people don't look at when they are signing up to some of these platforms. Then for the resolution of dispute, I think aside from litigation, there's also alternative dispute resolution, and there are forums for it, like WIPO and some other ones that exist. So thank you very much, Clarice. We'll be moving to Tony. Are you ready now? Tony, let me know if you're here and if you're ready to present.
Yes, ma'am, here.
Okay, Tony.
Okay. All right, so my topic is intellectual property in healthcare. Intellectual property, like as we all know, are protected under different disciplines like commerce, technology, education, and many others. However, when it comes to intellectual property in healthcare, they're usually protected under patents. What are patents? Patents are public policy instruments aimed at stimulating innovations by providing a monopoly through a patent, which gives the inventor an economic advantage, and it gives the patent owner a right to restrict other people from using that particular product. Now, when it comes to healthcare, usually the law and policymakers generally, they try to protect monopoly on the part of these patent owners, because like medicine and vaccines and things that are created by in the healthcare industry are usually seen as in the public interest. So protect the law seeks to protect the people that that benefit from these things. And usually a person who has a patent usually seeks to make profits from these particular vaccines or the products he makes. And the things that they can do, they can provide artificial scarcity or increase prices, which makes it inaccessible for people who are poor or people who don't have advantage to access these things. So generally, agreements like the 1994 TRIPS agreement and the 2001 Doha declarations basically provide for a general rule that does not allow these patent owners, especially when it comes to healthcare products or things that relate to a person's access to healthcare, make them very low and accessible to people generally. And it restricts them from like exploiting the general masses. Thank you. I'm done.
Okay. Thank you very much, Tony. How was your exam?
It was fine. Thank you, Ma.
Okay, thank you. Beautiful presentation. So let's call on Mr. Marx to give his comments on your presentation. Over to you, Mr. Marx.
Okay, thank you, Juliana. Yeah, that was another good and important presentation because people a lot of times, I mean, I have friends who are not lawyers, who don't understand IP, but maybe understand trade and understand economics, who always wonder, why the law should allow patents, for instance, why allow people getting, because the whole idea of the economic model that the world operates, the Western capitalist model, which is based on what we call the open market economic theory, is that you are supposed to allow a market determine market forces, determine the forces of demand and supply and all. Don't allow people to have monopolies so that they don't abuse the dominant power they have. Because the whole idea of a monopoly is that once the person has a monopoly, what it means in essence is that he doesn't have competition. And because he doesn't have competition, it means therefore that he can wake up overnight and choose increase prices, for instance, or lower quality. And because there's no alternative that consumers can run to, you are forced to patronize him, and therefore that becomes the power he can do that with, to the detriment of overall of the market and consumers. But I try to explain to them that they must understand that just like everything in life, they are always extreme, and there's always a need to balance things out. So if you allow market forces unhindered to determine everything, then at the end of the day, you're going to end up with the same problem you are running away from. Because if market forces alone are left to determine this thing, then the question is, with this market forces usually are based on immediate quick-term profit. But then there are some times where the society has benefited from longer-term research and development. Research and development costs a lot of money. And if you are going to put your money to research and development, then the incentive to do that is so that at the end of the day, I'll be able to recoup my investment. I'm going to have a way to recoup my investment before everyone else can benefit from the results of my research and development. So, for instance, Oxford University put a lot of money, along with I think it was the Pfizer that worked with them, put a lot of money to developing the COVID-19 vaccine. So imagine if after spending all that amount of money, let's say assuming a billion pounds, for instance, and then once the vaccine is available, any other pharmaceutical company can pick up that vaccine, reverse engineer it, create the same vaccine, and begin to mass produce and sell. It means therefore that the money spent by the university and the company in research and development, it will be difficult for them to recoup it, because anyone else can come into that market and take out what would have been their profit as well. So the balance now is where patent law comes in to create that monopoly to allow the person who invested in R&D, for instance, a 20-year window to recoup your investment and allow, and then make available for public benefit your information or your invention. So you can see that with that, there's a balance struck. But however, when you come to drugs, for instance, what we call, and then some other kinds of patents we call standard essential patents. These are patents that have the greater public policy interest in them. So drugs, for instance, COVID-19 vaccine, for instance, is something that the whole world needs. So if you allow anybody to have a monopoly on that, even for 1 month or 2 months, you can imagine the level of profit that person will be able to make out of it. So the law tries to balance it. There are certain times where, even though we are doing a monopoly, we can insist that you must license that monopoly. So that becomes a compulsory license. So easily, for instance, the COVID-19 vaccine could be mandated, giving out under compulsory license to other people to also produce, for instance, high demand, and then to ensure that price can be properly modulated and regulated. So these are different approaches that come with that. So I think it's just to always have that at the back of our mind that there's always that tension between competition law and intellectual property law, particularly patent, because of monopoly. So it's just a good thing to always have in mind. So now the all from Juliana back.
Okay. Thank you very much, Mr. Marx. Over to you, Mr. Folarin.
Hello.
Yes, sir.
Okay. Thank you, Juliana. I think, let me see. The patent conversation and the entire, this whole conversation is about balancing, the rights of access to information versus, for example, is a balancing act really. And the trade-off you make with filing a patent is that you disclose the how-to and so on and so forth of your, how you came about your miraculous invention. But I think maybe it would be good if we could focus more on the how-to, because in this part of the world, we've not really benefited from the notification component of the patent system. And what I mean is, people search patent registries looking for, oh, how did this person do it? Oh, this guy has a patent. Okay, in exchange for that patent, we will find out how you built that thing or what you did to invent that thing. But over here, the patent registry, if you go there now, you might clean the cobwebs, from their compactors where they keep the files. And you find also that the people who actually conduct searches and file applications are foreign companies. So I would want maybe if we could have a conversation or focus more on the disclosure component and how Nigerian inventors, if there is such a thing or such a group of people, can actually benefit from the disclosures being made by patentees, not for the purpose of infringing on the patent, but for the purpose of developing our own state of the art, and the general state of, for those who are in manufacturing, for engineering, and so on and so forth. So I think that's my little contribution. It would be a good idea to look at what the impact of the disclosure elements of whether people are actually actioning it and whether the patent system is working for us in that way. Thank you.
Thank you very much, sir. So, thank you for the contribution, Mr. Marx and Mr. Folarin. What I wanted to add, although Mr. Marx has already spoken about it, is compulsory license. So we know that people that are in the medical space and the pharmaceutical space, those that produce all these things, do a lot of research and development. And so by the time it's time to bring these things out, some might be a bit slow in granting licenses or producing these drugs, or probably they are able to conduct the R&D, but they don't have enough funds to actually produce this drug in like a large quantity. So what the courts can do in that regard is to grant a compulsory license to ensure that that particular drug is maybe mass produced or sold at a price that is not too expensive. It's also done in the music industry. So for people that make cover songs, etc., there's also a provision for compulsory license. So you don't have to go to them directly. That's for music now, not for medicine. If you are doing maybe a cover song, you might not have to go to them directly. Once you can file your songs digitally, correctly, and you put the right people that own those things, they can always just remove the 9.1 cents for every sale and just give to them. So that's the kind of thing that they also have in the medical space and pharmaceutical too. There's also something about the compulsory license. So, but I'm not sure of the particular convention or agreement that actually provides for this. So you can just go ahead to read about compulsory license. Then I also listened to your presentation where you said that the protection for it is majorly patent. So I want to say that aside from patent, drugs or pharmaceuticals can be protected also using trademark. So if there's a particular name that drug is called, then you can protect it using trademark. And if there are specific methods to the protection of that, you might do the patent, yes, but some can also be protected using trade secrets. And then there's also trade dress. So there's the popular case of, I think, purple pill. That's also a trade dress, but I don't think it's done in Nigeria, but it's done in other areas of the world. So these are also different things. So if you're looking at a particular product, you don't have to look at it with just one protection. You have to look at it holistically. So for this particular drug, you can do a trademark, you can use trade secrets, you can use trade dress, you can use patents, etc. Thank you very much, Tony. Let's listen to Michelle. Hi, Michelle, are you here? Okay, if Michelle is not here, then let's listen to Daniel.
So good evening, everyone.
Good evening, Daniel.
Good evening, ma. Okay, I just want to, I discovered I have two presents on this Zoom. I was trying to work with my laptop, but I discovered I had issues with it, with the audio, so I had to connect with my phone too. So I'll be sharing my screen with my laptop.
Okay.
Yes, I decided to look at image rights. What inspired me to delve into this was a discussion that I was having with a friend, and we were arguing on who would own the photo of a celebrity. If a photographer took a photo of a celebrity, who would own the image rights? So that inspired me to do some research on it. I actually wanted to present this last week, but due to my health, I could not. So I will just delve into the write-up, into the discourse. So I started with an hypothetical scenario, which emanated from my discussion or my argument with my friend. In my hypothetical scenario, I painted a scenario where Mr. A photographer, took a picture of Mr. B, a popular Nigerian celebrity with large following on social media. Then Mr. A decides to commercially exploit the photograph as the photographer. However, Mr. B is not satisfied with that decision, so he's very furious and has instructed his lawyers to write a cease and desist letter to Mr. A from licensing his image without his consent, claiming that he has the image right to the picture. So now the other question now is, who owns the image right to the picture? Is it the person in the picture, or is it the person who took the picture? However, this scenario just depicts the debate on who owns the intellectual property to an image. But image right also goes beyond. It's not just restricted to photographs alone. There are other areas of image rights. There are other scenarios that has to do with image rights. But this is just one of, I think, the most popular debates, ongoing debate about image rights. So I quoted Davidson Oturu, a partner with ALX, who said image rights extends beyond photographs. So it's beyond photographs. It has to do with also the signature and so many other stuffs. So, and then I tried to define image by Ayokunle Adetola, who defined image as a physical likeness, representation of a person, animal, or thing, photographed, painted, sculptured, or otherwise made visible. So he defined image right as, we say image right is the control of the image of a personality, not just restricted to the picture, which we can also say involves the person's personality, his name, his photo, his likeness, the person's signature, the person's brand. Now, brand, we know, it also brings a lot of money these days. Slogans, the person's slogans, the person might make a particular slogan, then it goes viral and everybody is accustomed to the slogan or the person's logo. So then I further stated that celebrities and famous people will definitely love to exploit their image to create economic value by lending their faces and voices to a brand. And we are seeing that now. For instance, we have celebrities who, for instance, maybe Glow, they actually use celebrities to who lend their faces to their products or their voices to their products. And due to the fact that these celebrities have large following, they use that to attract their followers to patronize them or to buy these products. So, and with this, with the usage of these celebrities' images, like we said, not just restricted to the pictures, their voices, their brands, their slogans, these brands increase their sales and increase their customers' outreach. In fact, not just within the country, sometimes even beyond their immediate environment. So sometimes this, for instance, Pepsi, for instance, I've seen adverts. I think there was the recent advert of Pepsi where Burna Boy featured in the advert. Now, because Burna Boy has featured in the advert with his voice, you see that many Burna Boy's fans would definitely love to patronize Pepsi. Would definitely want to love to buy Pepsi products. So also they also used I can't remember the other artist that was in that advert. I think Messi was in the advert. Popoga was in the advert. So fans of Popoga who are in England, all over the world, would definitely would love to buy Pepsi because uh, they are celebrity or someone who they look up to. It was in that advert. So these brands always increase their sales and customers, even across different geographical locations, due to the usage of the images of these celebrities. Sometimes celebrities earn more money, a lot of money from this endorsement, sometimes even more than in their career. I stated, I think I was reading somewhere, it was stated that, I don't know how true, that the brand endorsement deal with Globalcom is worth 50 million. And there was another one that Nyanya was signed a free $50,000 endorsement deal with Xerox Computers for the use of his image in 2018. And of course, we know that great stars or the arguably best players for almost 2 decades now, in terms of Ronaldo and Messi, they earn millions of dollars. I mean, all of millions of dollars for the use of their images. So image rights brings a lot of money. Image rights, image rights, image rights, image rights attract a lot of money for celebrities, a lot of money. I'll just go further to the fact that now the fact that they accrue a lot of money from the use of their images, definitely we expect them to protect their image rights from unauthorized usage. Um, there was a case that I came across, and I think most of us will be aware of the case of Rihanna, Fenty, and others against Arcadia Group's Brands Limited, um, TA Topshop. In that case, Rihanna sued Topshop, a clothing company, for the unauthorized usage of our image in a video, in a music video, in a video shoot. So they used the picture, the images on that video shoot on the t-shirt, and this t-shirt sold millions of they sold a lot of copies of that t-shirt. So, but the company was claiming that they had a license from the photographer to use that image. But Rihanna was claiming that the usage of that company, the usage of our picture, would deem to be an endorsement for that cloth. And the courts upheld Rihanna's argument and even an inch the court inch its decision on passing off and held that the usage of that picture of on the t-shirt would depict that Rihanna as it was endorsing the sale of the t-shirt. And there was no way that Rihanna was compensated for the use of her image. So that's something that it's very, very, I think it's a slippery slope for me because if we look at it from our own angle of copyright law, where the, although I'm getting there, where the owner of the person who took it's the person who creates a particular product or that has the copyright to that product or to that work, who creates the work is the person who has the copyright to the work. But for me, this is actually a slippery slope. If we're to compare it to a copyright, I think the photographer would definitely own the rights and can license the usage of that image. However, in 2016 too, we had a Nigerian popular actor, RMD, who sued Jumia for featuring his image on Jumia's fashion Instagram page. And of course, RMD is a very popular Nigerian actor, and his fans would definitely love to get the t-shirt or whatever Jumia was doing on their Instagram page. I really don't know if this case actually went on. I tried to look for the update on the case. I couldn't find any. Perhaps my guess is that maybe RMD withdrew the case from court and they actually settled out of court. Now, for me, I think I'll just proceed. Now, I'll just proceed. There are also cases where I think I'm having some issues here. Please, can you hear me?
Yes, we can hear you.
Okay, I think I don't know what's wrong but I might not be able to share my screen further because I think there's an issue. So I'll just proceed. I'll just continue without the screen. So there are also cases where there are reported cases of where the photographer and photographers have sued celebrities too for posting images without their consent. There's an instance of Kim Kardashian who was sued by a photographer in 2018 for posting a picture of herself and her husband on her Instagram page. The photographer claimed that he took the picture maybe in a gathering, and so that he has the image right to the picture, and Kim Kardashian should not have posted the picture without his permission or consent. Now, the question in my mind is, or the question which led to the debate between my friend and I, is who owns the image rights? And is it the celebrity or the photographer, or it might not even just be restricted to celebrity? People take our pictures, and so who owns the image rights and who can commercialize this image rights? And so for me, I decided to look at what are our laws, what is our law saying about image rights. Now, in Nigeria has no federal law or a comprehensive law providing for image rights, and this is not peculiar to Nigeria. The United Kingdom, where we developed our roots from, where we got our roots from, and most of our laws are fashioned after, does not also have a specific law governing image rights. And also the US does not have a specific law governing image rights. However, in the United Kingdom, a person can succeed on passing off, on trademark, and I think Article 8 of the European Convention on Human Rights, engine of privacy. In the US, there are states that have passed laws on image rights. I think New York has, I think Texas has laws on image rights, but there's not this there is an absence of a federal law, just like Nigeria, on image rights. So there's I think I'm having some network glitches. There's an absence. Please, can you hear me, ma? Can you hear me? I think I'm having some.
So please, yes, I can hear you. Yes, I can hear you. You can continue.
Okay. So, like I said, there are related laws in Nigeria that we can look at to determine who might own an image right and also possibly protect an image right. One of such legislation is the Copyright Act. For copyright, Section 6 provides that the owner of a copyright has the exclusive right over his work. So now the question is, who is the owner of a particular work? The owner of a particular work under copyright, someone who has the originality of the work. So for image right now, definitely the person who as the originator of the work, or will be the photographer who actually took the picture. So in this instance, definitely the photographer would own the copyright to the image. So in my scenario that I stated, Mr. A would definitely have the copyright to the work, and except where Mr. A and Mr. B otherwise agree, and where it's where both of them stated uh, that Mr. B was going to have the exclusive right to the work. Otherwise, Mr. A would definitely own the copyright to the work. Or according to Davis and Oturu, um, if there's an employment or in an employment issue um, where it is the responsibility of Mr. B to take the photos or to take photographs of Mr. A and is paid for it, definitely Mr. A will be deemed to own the right to the picture. Mr. B definitely rather the celebrity will own the right to the image. So I went further to state that a person owning the copyright definitely will be the photographer. But however, a celebrity might bring an action in court under Section 37 of the 1999 Constitution, hinging on the right of privacy. Now, the celebrity might succeed for the breach of his constitutional right of privacy if he can persuade the court to construe that right as not limited to the just institution of his private life, but extending to the usage of his image for commercial benefits. I think I also got that from that was from an article from Olaniwa Ajayi. It's not a 15 article, image right chatting new parts, where the author explained that Section 37 can be used, a person can rely on Section 37 to prevent an infringement of his image rights, where he can claim that that image is being used for exploitation for commercial benefits to his detriment. Also, a person can also bring an action under trademark where the person has trademarked the particular image, maybe his brand, his logo. Definitely, the person will succeed under the Nigeria Trademark Act or for an infringement of his trademark. There's an instance where Cardi B actually trademarked two of our popular catchphrases, ok and ok. I mean, so that means nobody can actually use that catchphrase without our permission or consent. And definitely she can also enjoy economic benefits from or enjoy economic rights from the use of that catchphrase. So I just quickly delve into the world of football. I also was trying to imagine in my head, okay, who was going to own the image rights in football? So I think in the world of football and some similar sport, maybe tennis, a player owns his image rights. So because it's actually a debate to who owns the image right between a player and a club. A player owns the image right. However, a club can use the player's image right for club capacity. And most times in the English Premier League, there's a clause that allows it in the standard employment clause, where the club can use the image right for club capacity. For instance, the club can where the player wants for matches, purposes of their matches, maybe their training, but just for club purposes, not for sponsorship purposes. So if the club wants to use the player's image right now for sponsorship benefits, they will need to enter a separate agreement with the player, or sometimes most of these players they've assigned their right to a marketing company, to a third party. So they would assign this right they've assigned this right to the company. So the club would definitely need to enter a separate agreement with the player or the marketing company. So then like I said, it might actually differ in other sports, but in football, I think that is what is tenable in the world of football. So I concluded by saying that, just to wrap it up, definitely a photographer who takes a particular image of a celebrity will be deemed the owner of the particular photograph under copyright law, and therefore has the image rights to that photograph, except where party have otherwise stated. Now, but that's not the end of the road for the celebrity. The celebrity can seek protection under Section 37 of the 1999 Constitution, under the Trademark Act, if the particular image is trademarked. Otherwise, infringement for that trade image right may continue unabated. And for me, I also feel that there's a need for a sweeping federal legislation on image rights. Some might say, well, we have it make our law porous, or we have enough laws to deal with infringement of image right. But I don't think these laws, we have sufficient laws to deal with the issues of image right, because we still need a proper definition of who owns an image right, the protection of an image right, and every other ancillary issues that borders on image rights. Because as we can see, there is a rise in endorsements of local and international businesses. We have people now, for instance, using Burna Boys in their brand, in their adverts. We have people coming down to Africa, because Africa is a huge market, and they are coming to engage African stars, African celebrities in their ad to promote their brands in Africa. So we definitely need a legislation on image rights to protect image rights, to define the ownership of image rights and every other every other issues that comes with image rights. For me, some might look at it that image rights only pertains to celebrity, or it's only a celebrity that can own image rights. No, that is not true. Everyone can have image rights. Everyone owns image rights. Everyone can pursue infringement of image rights. But the only issue is that most times celebrities are the one who have pursued and won cases bordering on image rights, perhaps due to the important factors of the ability of the claimant to demonstrate that he enjoys goodwill, and his goodwill will be infringed by the continuous use of his image, or he has considerable influence out there. He has maybe large following on social media. His words, his images matters a whole lot, and his images can influence people to carry out a particular action. So perhaps these are the limiting factors on why celebrities are the only one who have pursued and won cases on image rights. That's the end of my discourse.
Okay, thank you very much, Daniel. Thank you for the presentation. When I actually saw your assignment, I was like, my God, Daniel wants to finish us in this class, because I think I was like, okay, let us limit it to 1 page, but yours was almost 3 pages, and that shows that you are very interested in this particular topic and that you really enjoyed your research, because it was almost 3 pages, and I was like, well done, Daniel. You're really trying. So thank you. The mentors are not here, and I'm not sure why. I think probably they're having network issues. But what I'll say about your presentation is, first of all, I think it's mostly celebrities that actually go ahead to try to fight for their rights. That's their image right or their personality right. And I think it's firstly because of the costs involved, and because they're actually aware of the value of their image. So yes, as you said, if I have a salon, or I have like an e-commerce site where people are coming to buy something, I might be tempted to use the pictures or the images of people that are recognizable instantly to drive people to my shop or to drive people to my market. And so, yes, people use more of celebrities' pictures and images than your regular person on the street. But I want to say that these celebrities actually go ahead to fight for their cases. Why don't they fight the saloon seller on the road? Because if you pass through, let's just say you're passing through Gwarimpa, or you're passing through Maitama, or you're passing through anywhere, and you see shops where they sell food, they sell clothes, the people in the picture that are wearing the clothes are people like Mercy Johnson, Jim Ike, etc. But you will not see Jim Ike coming to sue someone that has a shop in Gwarimpa or Kubwa. That's for those that know Abuja. They will not come and sue them, because they know that they will be spending their money, and these people will not even have what they need to pay them back. So most times, the people that they would sue, if they actually use their images, etc. It's actually people that have the means to pay them back, except they're just trying to make a statement or just try to create precedents for the legal profession. If not, aside from that, they don't actually sue. Like most of the saloons, all the saloons have pictures of white people, pictures of Nigerian celebrities, and these saloons have been on for 5-10 years, and there's no celebrity have come to say, oh, why are you using my picture in your salon? So most of these cases are actually selective based on who can actually pay them for these rights. But as you said, I think that it's open to everybody. The only thing is that the ordinary person might not see the use to start pursuing that, except someone that is quite known. So even if you're looking at, if you're looking at the tech space now, they might use a face like, there's a tech guru, I'm trying to remember his name, someone that is into the tech space and is into the funding and funds like a lot of these tech people. They might not use Richard Mfedamijo. They might go to use his face. Why? Because tech people will recognize him in that space. So people have to look at all this and then they'll decide how they want to go about it, whether they want to sue, if it's worth it, alternative dispute resolution, etc. Then I actually agree with you on the legislation for this. Yes, you spoke about the section in the that's in the Constitution. You also spoke about the section in the Copyright Act, but I think it would be good to have something specific to this image right. Then lastly, I'll be speaking about the copyright and image rights are different and they should be seen differently. So if someone is taking a picture of another person, that falls under copyright. But the person that is in the picture is the person that can say that they own the image rights to it. So if someone needs a license for that, there might be no harm in seeking the license from the owner of the copyright and the owner of the image rights. So even in music, there are like bundles of rights inside a particular IP. So if you are looking at music now, there's the composition rights. Aside from the composition rights, there's also the sound recording rights. So if somebody wants to use that song in a film, let's say a synchronization, if they are trying to obtain a synchronization license, they cannot say, oh, I've gotten the license from the songwriter, so I will not get the license from the record label that owns the masters. No, they have to get the rights from both the songwriter, publisher, and the rights from the record label or the owner of the master recording. So that you get the rights from one person does not say that you're not supposed to get it from the second right owner. So I think it's just something that you need to look at. And you also spoke about the employer-employee relationship. So if the owner of the image right is the person that employs the photographer to take the picture, then yes, that employer should be or might be the owner of that particular work. But if it's an independent contractor, then they might not be the owner. And if they're like a freelance photographer, they might not also be the owner. So it's good that if someone is interested in exploiting commercially or economically the rights in a particular photograph or the image, etc., nothing stops you from investigating who the owners of the rights in that particular IP is, and then writing to all of them to get the appropriate protection. So if it means writing to the copyright owner, fine, you write to them, that's the photographer, and then writing to the person that is in the photograph, that's the owner of that's the person with the image rights, him or herself, then that's also something that can be done. Thank you very much, Daniel. So let's hear from Michelle. Hi, Michelle.
Good evening, Miss Juliana. Please, I just want to connect my laptop so I can share my screen, or I don't need to.
You can do that. or you can start while you're connecting, whichever works.
Okay. Okay. Sorry, just 1 minute. Okay,
So,
good evening, everybody.
good evening,
My
Michelle.
topic is on copyright infringement. And basically, I talked about what copyright infringement is, and then the remedies that are available. Okay. Hello?
We can hear you. We can hear you.
Okay.
We can hear you and we can see you.
Okay. Good evening, everybody.
Good
So
evening.
my topic is on copyright infringement. And I talked about what copyright infringement entails and then the remedies available, basically. Okay, so copyright infringement. Please, can you hear me?
Yes, we can hear you.
Okay, copyright infringement is the unlawful use of works protected by copyright without permission for a usage where such permission is required. I think it was one of the persons I learned from this. When I thought of copyright infringement, I didn't think that you can just infringe on any work if permission is not required to use the work. I think maybe the example they are making here is maybe where the work is, where it's for educational purposes or something similar. I'm not so sure, but um some examples of acts which will be regarded as copyright infringement include recording a film in a movie theater. So we see a movie, for example, what's the name of this? Coming to America now, for example, and we record it. Maybe we put it on our status or we put it on our YouTube channels, something like that, without the permission of the actual um, director or producer or creator of the movie or the owner of the movie. Also posting a video on your company's website which features copyrighted words or songs. I think this happens a lot also on Instagram, for example. You post a video of yourself dancing to a song that is copyrighted and you do not do so without the permission of the owner of the song. In that case, you would have infringed on the musician's copyright. Also, downloading music or films without paying for their use. This is the same example as well. I'll use Coming to America. So I don't know if I'm the only one that watched it, but I didn't watch it in the cinema. Downloaded it from a website, watched it without the person's permission, to be an illegal website now, exactly. Even if it's not an illegal website, but a website where the movie is posted without the owner's permission, copying any literary or artistic work without a license or written agreement, artwork, a book, a journal, maybe somebody wrote did a book, published a book, you copy without the person's permission, without any license from the writer, without any written agreement from the writer saying, okay, you have permission to use my artwork, you have permission to use my book or my journal or something like that. It is important to note that the mere fact that the person created a work does not automatically qualify the work to benefit from the protection of the act unless the first one says sufficient effort has been expended on making the work to give it an original character. That's one. And secondly, the work has been fixed in any definitive medium of expression, now known or later to be developed, from which it can be perceived, reproduced, or otherwise communicated. So, for example, I think of a book in my mind. I think, oh, I want to make this movie, and then I see somebody else that has made a movie similar or copying what I have made. I cannot say, oh, you've infringed on my copyright when it has not been fixed in a definite medium of expression. It cannot even be perceived. It cannot be reproduced. It can't be. There's no tangible. Is there a word like tangibility? Probably not. But there's no tangible evidence to say, okay, this is my book, this is my movie, this is my artwork, anything like that. It can't just be something in your mind. First of all, intellectual property, yes, protects the product of your mind, but then it has to have been seen, it has to have been fixed in definitive medium of expression, it has to have been displayed before you can even say, oh, I have copyright in this work and I want to protect this work. In Nigeria, Section 14 of the Copyright Act provides that a copyright is infringed by any person who, without the license or authorization of the owner of the copyright, does or causes any other person to do an act, the doing of which is controlled by copyright. Same thing as I have said before. Okay, here it includes causing somebody else to do an act. So maybe, for example, you are the publisher of a publishing house and you order your employees to print a book which has been printed already, or you to print um, fake copies of another book now, for example. Now, the remedies that are available, okay, yes, sorry. Also, according to the Copyright Act, an artistic work would also not be eligible to be infringed upon if at the time when the work was made or is made, it is intended by used as a model or plan to be multiplied process. So if the idea of you creating that work was for it to actually be used as a model, so I think the example, I'm trying to remember an example that was used by my lecturer, but I think maybe an architectural work or I don't know what they call architecture, but for example, estates now, for example, that they create an architectural design of how they want all the houses to be, and then it is made public. So you know that if you're buying this and a house in this estate, you're buying land in this estate, the house you're going to build is going to be according to this. That architect now created that model to be used and be multiplied, to be used in I'm not sure about this example, but this is what comes to my mind. To be used to build other houses in that estate. Can he now come out and say, oh, you infringe on my copyright by copying it, when the initial reason he made that was for it to actually be used as a model or a pattern for people that are buying houses in the estates? For example, remedies available. The Copyright Act in Section 16 provides that all infringing copies of the works in which copyright subsists or any substantial part thereof shall be deemed to be the property of the owner or author or owner. So if you have a work in which copyright actually subsists or existing, that copyright is your own. You are the owner of the property of the copyright. You're the owner of the work in which copyright subsists. So the remedies available could be damages, monetary compensation, which could either be special or general damage. General damages, okay, this is what we go generally for an act like this, or special. For example, what you did, maybe the infringements, maybe you copied a movie, you copied an artwork, you copied a book, and the court decides to give you special damages to pay to the owner of the copyright. Can also be an injunction, which would involve restraining the person from further infringing on the copyright. It may be an interim injunction at that moment, maybe pending final trial. It can be interlocutory, it can be perpetual, which will prevent the defendant from being involved in infringing that copyright any longer. It can also be an account for profit. So maybe you're a company which has been involved in infringing a work in which copyright subsists. You'll be ordered by the court to display your accounts, how you sold those products or those items, the profit you made from it. Then copyright infringement may also carry criminal liability with penalties of fines and terms of imprisonment. The Nigerian Copyright Commission is usually the prosecutors of such action. However, the fact that a criminal action has been instituted against the infringer does not deprive the copyright owner of his own right to institute a civil action. So if the Nigerian Copyright Commission decides maybe they raid a company that is so into infringing and copying, illegal infringing, illegal copying, illegal piracy, and they want to prosecute, so that would be against the state. I don't know, Nigerian Copyright Commission against the defendant. It doesn't stop you as a copyright owner from actually instituting a civil action against that infringer in court. The case Example, NCC, Nigerian Copyright Commission versus Okechukwu, in which the accused was sentenced to 3 months in prison and I didn't check the year, I'm sorry about that. In prison and ordered to pay 12,500 in fines after he was found guilty of selling infringing copies of cinematograph films and musical works. So in this situation, this was the Nigerian Copyright Commission that instituted a criminal action against him, and he was found guilty. He was sentenced to 3 months in prison in order to pay fines. In this situation, where maybe he infringed on a particular author's books, for example, okay, they said movies, a particular director's movies, a producer's movies, the producer can also institute civil action in court against Okechukwu, while the Nigerian Copyright Commission can also institute the criminal action. Thank you.
Thank you very much, Michelle. So I was just going through to check if any of the mentors are around. They are not. But thank you very much for your presentation, and I'll just touch on some things. So your presentation is copyright infringement. What I want to talk about is when you see books, some will have that sign that would say copyright or all rights reserved, meaning that the person wants to keep their rights. And then if you should look at some websites, you would also see like that sign for the copyright, and you see all rights reserved. Same for some other creative works. But there are exceptions to this that can make someone to use like that particular copyright without maybe they'll just acknowledge you, but without seeking your permission up front and then paying you for it, and that's fair use. So for like educational things that fall under fair use, they might not reach out to you for that. Then I also wanted to talk about Copyleft and Creative Commons. So maybe when you have the time, you can just go to look at it. So there's Creative Commons. That's when somebody brings out a particular work and maybe they put it out for free, or they give certain instructions on how they want you to use their work. So if you want to look at WIPO now, some of their materials, they'll tell you that you can use their materials, that you don't need to reach out to them prior to usage. But what they'll tell you is that if you want to create a derivative work out of it, then you should not quote them as that this work is coming from WIPO. Or so that's just like an example. So for some people, they do not actually believe in putting a price on their creativity. So they give out their things for free. Even in the tech space, we have that like the open source work and all that. So what they do too is that different people can just come in and improve on whatever thing they're working on, and it will be open for people to use and all that. So for those particular kinds of work, if you should take it and you should follow the instructions, that's like the guidelines for the usage, then you would not be infringing on their rights. But where someone has outrightly said that this particular work falls directly under copyright, then using the work for maybe for a commercial purpose, etc., would be infringing on their rights. Some of the social media platforms, because of the back and forth of, oh, this is my right, this is not my right, etc., what they do is they just create a system where whenever you use another person's work, they just have a way of monetizing it, so that they just give like the monetary value to the owner of the work. So if you put something on YouTube and you use another person's song that has been monetized already, what they would do, they would just indicate in the description that this particular work is for this person. And they would then tell you that if you want to contest this, send a message or something like that to them, and then they'll monetize it, and the money from it will be given directly to that person. So I think that's just one way that they've been able to solve that problem, but it's not applicable to every online site. So for Twitter, I think if you should be dancing to someone's song or something, by the time you do it like that, they might just block you, and then they'll tell you the reason why they're blocking you, because you're actually reducing the economic value for another person, or that's the owner of the work. So if people would have actually gone to Spotify to go and listen to the song and everything, they might decide to put that song on repeat on Twitter and be listening to it. So the person that owns the works actually losing out from it. Then also there's a compulsory license thing too, where instead of them to reach out to you directly, they can just go through other means, but you will still be paid for it. And then you already stated the remedies which are available. So I think that's it for the copyright infringement. Those are the things that I had in mind. So you can just, during your free time, you can just go and read about Copyleft, Creative Commons, Creative Commons, I think, yes, open source, etc., so that you can understand like the alternative to copyright that some people go for instead of copywriting their work. So thank you very much, everyone, for attending. Next week, we'll be having someone that will come and talk about film law, Fosa. So you can just go and check her out. She's like a guru in the entertainment space, and she knows her work. So she will be here to talk about film law, because I know that a lot of us have been writing about film law, Yolo Toure case and the whole chain and all that. So she'll be coming here next week to talk about film law. So I encourage everyone, you don't need to submit assignments for next week. Just prepare to ask your questions so that she can answer. I noticed that when I bring people here, and I bring them because we talk about those things. And so I think, okay, it would be good for someone to elaborate on those things, but I end up asking more questions than everyone combined. So I would like us to just go and research about film law, put your questions down so that by the time she comes to take that presentation next week, Friday, we can ask our questions and engage her. Last week, I enjoyed the engagement with Mr. Folarin on litigation, fees, and everything. Maybe because it has to do with money, but I assure you that if you can engage on all these IP topics, you don't know where your clients will come from. Like my father-in-law will say, you don't know where the white man will come from. So just open your ears and your hearts to different areas of this IP, because you don't know where your clients might come from. You might actually enjoy maybe research and development, like Clarice. I'm not sure if that's what she likes fully, but I'm just saying that, let's say that your passion is research and development, and you now decide that you're not interested in music law, film law, etc. By the time you're ready to practice, you might discover that the clients that come to you more are actually coming for film law and music law. So what will you do when you do not really listen to it? So it's good for you to listen and engage. And even by the time you engage, the facilitator will even take note of you, and you can then private chat them subsequently to ask them further questions. So it's good for you to try to engage. And I also noticed a lot of us are very particular about keeping our faces private, which is also okay. But there's something about like a bond and a connection when someone sees your face and someone sees your reaction to things. It also helps them to bond with you. So if you meet Mr. Marx on the road now, or you meet Mr. Folarin in a flight, so what will you be saying? Oh, I'm that Benis that was in that first JIIPCC mentorship session, and you'll be like, oh, okay, but he doesn't know your face and he cannot really recognize you. So you'd have to explain more. So that's part of the reasons why it's also good for you to show your face in some of these kind of meetings, so that by the time you want to interact further, it will be easier for you, and there can also be a bond. So I'd like to say thank you to Michelle for showing us her face today. Lastly, we will be rounding up the session for this particular mentorship class on the 2nd of April. So I encourage everyone to prepare your 3 to 5 minutes talk on the program and what your plans are for the future. You never know who might be interested in you or in your own career path. And we'll be starting the next session in April, hopefully. So if you know anyone that might be interested, please direct them to send their email and their CV to the email in the flyer. Thank you so much for staying. I know that you actually have to download a lot of data and all that to be able to attend these sessions, and most of us are young lawyers. Thank you very much for staying and for being committed to your passion and to your purpose. Enjoy the weekend. Take care and stay safe.
Thank you, Ma.
Thank
Good
you, Ma.
night. Thank you.
Good night, Ma. Thank you, Ma.
Okay. Take care. Let me